The English legal system. What we're going to do here is the law question covers about 7 marks in the exam, and it seems to be a lot more about why and how laws are made and operated rather than long lists of legal facts. It also as well covers the English legal system, but it also covers as well contract law. So we need to be careful here with this question that we don't end up taking up far too much time. It's also as well the first sort of chapter that comes up in most of the books as well, really, but it's not really as remotely important as other areas. So we need to go to an approach to make sure that we maximise our marks with the time available. So what we're not going to do is we're not going to focus on learning things parrot fashion. Don't do that. You'll use up far too much time. Instead, we're going to go through understanding it, and also key points for general revision, and then in the video I'm going to run through lots and lots of it again, so you can just run this and let it sort of sink in, really. So that's the approach that we're going to do. We need the marks. We need the 7 marks for the English legal system and the contract law part of it, but we can't spend too much time on it. So in terms of the English common law system, it applies equally across the whole of the country. Common law is built up from previous customs and judges' decisions, so that's where the common law system comes from. So we've got lots of precedent, lots of judges' past decisions, whatever, coming up in the common law system, and it applies to across the whole of the country. So the common law system applies to everybody. Equity laws, though, take precedence over common laws. And what equity laws are trying to do is trying to promote fairness. So they do 2 things. One, they sort of mitigate against common law decisions if the common law decisions seem to be unfair. Previous judges' provision or precedent seems to be unfair in this situation. And also as well, they allow for more than just monetary damages. So common law is just monetary damages. Equity law is it allows for equitable damages as well. Where those equitable damages are more fairer and monetary damages aren't sufficient. Statute is laws made by Parliament, so they take precedent over common laws and equity laws. So statute's the main thing, really, and that's where the elected representatives have come along and they've decided that common law or equity laws aren't right, or a past judge's decision isn't correct, and they change the laws for the new circumstances in here. So let's say if we took homosexuality was once illegal within the country, it's decided that's not going to be the case anymore, and Parliament decides to repeal those laws. And even if a judge didn't like that, wanted to look at previous decisions or whatever, they couldn't do that because Parliament statute takes precedent over previous decisions. So previous decisions by judges, what I've just mentioned, judicial precedent, they're binding on all future equal and lower courts. And if the facts of the case are the same, then the facts of the case have to be the same. The judge making the decision and the judge making the decision provide the reason for their decisions, and they weren't misinformed. Now, what's the point of judicial precedent? Judicial precedent is to make sure that we don't keep retrying the same case again and again and again with the hope of a different outcome. So we'll go through that in detail, but essentially that's what it's trying to do, is speed up the legal system to just make sure that we don't keep redoing the same case again and again and again, with people just bringing constantly the same arguments. Public law covers the state and public bodies. And so they sort of governs behaviours by individuals. So things like criminal acts, that kind of thing, parking fines, those kind of things. There, though, it's the public or the state, public body or the state. So the police or it's the Crown or a local authority bringing a case against an individual. Private law covers behaviours between individuals. So that's where you and I have a contract, and you've decided to breach the contract, and so it covers the behaviour between you and I. Really. Criminal law is part of public law. So criminal law is part of public law and designed to punish offenders. So it's an important thing about criminal law is that it's about punishment. Whereas, so in terms of criminal law, we're punishing as well. Burden of proof is on the prosecutor to prove beyond all reasonable doubt that the defendant committed the crime, and also as well, it's not in this law, that they were of guilty mind. So in order to be convicted of a criminal act, you have to both have committed the act, broke the law, and you also have to be of guilty mind when you broke the law. Now that's capability. So you can't break the law if you're insane. Let's say. You'd be committed to a mental institution, so that you couldn't actually continue to break the law, but you are actually a criminal. Whereas if you are capable of knowing right from wrong, but you are ignorant of the law, that's not a defence. Civil law is part of private law, and that's between parties. It's designed to ensure fairness and considers losses by one party, the claimant, where that loss was against the law and the loss could be reasonably foreseen by the defendant. It's important to note that reasonable foreseen by the defendant. You can't have sort of things that the defendant wouldn't have reasonably foreseen. Civil law is only designed to restore the successful complainant to the position before loss. So the damages or other equitable sort of remedies, really. It's not designed to punish the defendant. So that's the important thing. So we've got differences between civil law and criminal law. Criminal law is about punishment, and civil law is about restitution, really. So it's not designed about punishment. Now that's different to the American legal system. The American legal system does have punitive damages in its civil law system. So let's say if you took the sort of Johnny Depp versus Amber Heard case, there are punitive damages against Amber Heard designed to punish her. That's not a feature of the English legal system. Tribunals are not courts. So tribunals are experts in the field, operated by a judge, and they might be an employment tribunal, let's say. So they have an expert in that particular field of law. They are not bound by the same judicial precedent, and so that does lead to inconsistencies, and they're less formal than they're less formal than the court. So an employment tribunal is the sort of key example of a tribunal system. Delegated legislation is where Parliament decides to delegate the authority to make legislation to either ministers or to authorities, so local authorities making bylaws for parks. So those are the key points. So what is the law and why is it important? So laws are the rules that govern the behaviour of human beings within a civilised society. So that's the sort of the definition that we're going to use in here. And in terms of the basis of our English legal system, so we start off with the common law systems created in the Middle Ages, where all the customs and practices are pulled together, that were different across the country, pulled together into one single common law system. It applies equally across the country and to everybody. Now, common law, in some instances, delivered very unfair results. It was sort of quite harsh, really. And also, as well, common law can only provide monetary damages. So, in terms of what we have there, so we have common law can deliver monetary damages, but nothing else. And it can be harsh in certain instances. So we have limitations on common law that sort of deliver these unfair results, and also as well in terms of the remedies that are available. Now, that could be really harsh on a particular party when they were acting fairly, or in favour of another party when they were acting unfairly. So what we have is the laws of equity. And laws of equity are developed to mitigate some of the harshness of common law decisions. Also, as well, it can try to ensure that there's justice in the application of laws, not just simply that the laws follow. So that's what it's trying to do. Where there's a clash between equity and common law, equity always takes precedence. Equity wins. Equity can also provide damages beyond monetary damages. So it can require somebody to carry out an action. So it can require specific performance. You and I have agreed that when I'm going to sell you an oil painting, it's by some famous artist. I decide that I don't like that anymore. You can require me under the law of equity to hand over the painting, provided it's not been destroyed. I can stop you. It can require somebody to stop an action. I can obtain an injunction to stop you doing something. Let's say you decided to chop down some kind of protected tree or something. I can go and get an injunction to get you to stop chopping the tree down. And it can cancel a requirement by somebody, so it can sort of a rescission, so it can sort of cancel a contract. So we've got an agreement that would be held together in common law to carry out this contract. It's probably very unfair, let's say, and it can stop that contract being carried out. So in terms of judicial precedent then, in terms of the English legal system, it is combative. There's an attack to prosecution in criminal cases or a claimant in civil cases who brings a case against the defence. If we kept going on and we wouldn't have some way of sort of stopping continual attacks and defences, we'd have the same legal points being tried again and again to try and find a different outcome. And so in order to ensure that the same legal points are not tried again with different outcomes, that's a key feature of the common law system is judicial precedent. So judicial precedent states that where courts already determined a point of law, it's binding on all future courts, unless a higher court. Now, a higher court is a more important court with more skilled judges. So let's say we have, a magistrates court that's got, laypersons. They're not actually legal experts. Really, they're supported by a legal expert, but they're not actually legal experts themselves. Whereas higher courts have judges in there, and then the very highest court, the Supreme Court, has the more skilled judges. So, a judicial precedent states that where a court's already determined a point of law, unless a higher court determines otherwise, that judicial precedent is binding on all future courts. What that means is if we've got a different the only what that really does then is it prevents the idea of our expensive cases being brought that haven't got much chance of success. It also means that you can decide, well, I'm going to defend a case, and I've got a very strong chance of defence because this previous court's decided exactly in our favour. So there's always going to be a lot of attempt by the attack and the defence to try and find previous cases to highlight that this particular case is either going to be successful or not. Now there is an exception. There's an exception to judicial precedent, and that's where if a party can claim or can persuade the court that the previous decision was made without due care, so it's pure per incurrum, typically because the judge is misinformed by making the decision, and so they might have not taken into account a ruling by a higher court. That's typically the thing. So there's this particular judge, let's say, and in the case is a judge that makes a decision that the House of Lords had already made a decision on in the past, really, and so they hadn't taken into account judicial precedent, and they were misinformed. So you can have this sort of situation then where essentially judicial precedent is a bit like if you have exploding kittens. It's like a note card, really. It just says, nope, you're not bringing this case in here, or alternatively, nope, you're not bringing that defence along there. So our decision then is binding if the judge provides a reason for the decision. So they provided a reason for it. They clarified the law. That's called ratio discendi, and rather than making remarks just in passing. So if they're making remarks just in passing, that actually it's not a judicial precedent. If the facts of the new case are materially the same as the previous case, then we're going to have a judicial precedent, and the decision was made by a court of equal or greater standing. Then we've got judicial precedent, and provided the judge wasn't misinformed, that they are that's binding. So we're now going to get into statute then. So although judges make decisions based on previous court decisions and customs, what happens when society just doesn't like the law anymore, the decision, or it wishes to change a custom? So if in that case, if common law was governed purely on previous judicial precedents, the laws couldn't change. So you'd have past actions, let's say homosexuality, or would be illegal. Alternatively, your penalties would be would still hang people. So society can make these changes, but how does it do it? Well, it does it via statute. So it changes the law, and so that's the governing body, Parliament, changes the law through statute and legislation. And statute overrides any common, any common law conventions or judicial precedents, any equity laws, anything. Just judges can't try and revive any old past customs just to cover any prejudice that may continue. Once a law is enacted, then there is a whole new round of interpreting the law by those judges, and those decisions then become binding on equal and lower courts in the future. Now, statute can either be primary, direct legislation, so those are laws implemented by Parliament. Alternatively, it could be delegated legislation, so we could have they could delegate the authority to certain things to either the Secretary of State for a particular area, or alternatively to an authority, let's say the local government. Right, now another bit you need to understand really is criminal versus civil law. So criminal cases where the state brings a case against an individual where they've breached the law. They breach the law and they're going to be prosecuted. In that case, what we would have then is the criminal law. The purpose of the criminal law really is to punish wrongdoers who have committed an offence against society as a whole. It should be noted that the concept of justice for the individual It's only really a very recent consideration that really with things like impact statements and whatever. It's not actually about obtaining justice for the individual criminal law. It's about an individual offending against society, and therefore society prosecutes the individual, and society decides what the punishment is going to be. The individual might feel that the correct punishment for murder, let's say, is hanging a person, or worse, really, but society is going to prevent that. It's not, the individual actually is not part of the criminal situation, even though there is constantly the request for justice for whatever. It's not a factor of criminal law. Civil law is brought between individuals, and so in civil law there is a concept of justice really here. It's brought between individuals of one party's claim against the other. The purpose of civil law is fairness, not punishment. So criminal law is about punishment of people who offend against society. Civil law is about concept of fairness and restitution. So it's restoring the person to the same point after the wrongdoing. Let's say forcing what would have happened if somebody would have completed the contract and being fair. But it's not about punishment. It's not about trying to punish the wrongdoer in here and let's say having additional penalties for breaking the sort of the civil law, or let's say the contract or whatever. That's very much unlike the American legal system that does try and deter future wrongdoers through the application of punitive damages. So if you're following American law, you have to be careful with this concept of punitive damages in civil cases, which is not a feature of the English legal system. So we've got our key features of criminal versus civil law here. So criminal's offences against society, not against the individual. The individual who's probably suffered, let's say whether they've been murdered or beaten up or whatever, but it's the society who's offended. Civil is harm against the individual and justice for the individual. In criminal, there needs to be a breach of the law, and the criminal needs to be of guilty mind. So they can't be convicted for insane, but they can be convicted of just ignorant of the law. In civil, they need to have done foreseeable harm and broken the law. So foreseeable harm, not unforeseeable harm. In criminal, the outcome is punishment, or not. Criminal, the outcome of breaking the law is punishment. In civil, it's restitution. So restoring the person to the same point before the harm is done to them. So that could be monetary damages, or it could be equitable remedies. In criminal, we have the attacker as the prosecutor, the defendant as the defendant, and in civil, the attacker as the claimant, and the defender as the defendant. In criminal, it's the prosecutor must provide their case or prove their case beyond reasonable doubt, and so the burden of proof is on the prosecutor in a criminal case in here, and that's important because the criminal outcomes are so severe. Or have such, to have a criminal record is quite severe there, and so the burden of proof is for beyond reasonable doubt. In civil, it's not. It's only on the balance of probabilities, so a little bit more than 50% is required for the claimant to be successful in their claim. The outcome in a criminal case is conviction or acquittal, and the punishment is fines, conditions on life or imprisonment. And in civil, it is the defendant's liable, and therefore the outcome's damages or an equitable remedy. So those are our key features of those ones. That's a useful table to have because you might have a question very much along these lines. In terms of our court hierarchy, so we're going to start at the bottom here. We've got our magistrates' courts here. Now, our magistrate courts are staffed by laypersons, so they're not actually legal professionals. They're not judges. They'll be supported by a legal advisor, but they're volunteers, not legal professionals. In the criminal ones, which is magistrate courts. In the civil side, we have our magistrates' courts, and we also have our county courts as well. So our county courts, we can have judges in county courts in here. So we would have our judges and our legal experts without the need for our legal advisor. We have three tracks in a county court. So small claims is less than 10,000. Costs can't be recovered in small claims. So you can bring a small claims one for less than £10,000. Costs you £75 to bring it, and the defendant can't recover their cost if you turn out to be a crank. Fast tracks between 10 and 25,000, and multi-track is more than £25,000 in here. And so these are the rankings, and the small claims being the lowest, multi-track being the highest in there. In these ones up here, these fast track and multi track, you can become subject to a decision for costs being awarded against you if you're incorrect in terms of the way in which you either decide to claim or defend. Next highest one, Crown Court for criminal. And so a magistrate who can't impose, let's say, a sufficient penalty that they think that they can is required for the crime, would refer the case to Crown Court. So magistrates would typically, so let's say in a murder trial, do the bail conditions for the individual, remanding them into custody, but the case will be heard by the Crown Court. And in the civil ones, higher courts of justice split into divisions based upon the type of claim, really, and the specialisms required. They both go to courts of appeal. And here courts of appeals if they got leave to appeal. And then once we've gone through the courts of appeal, we've got the Supreme Court. Previously, it used to be the House of Lords, not anymore. Now it's the Supreme Court. And once you've gone to the Supreme Court, that's it. Decisions were made, and now judicial precedent is binding on everybody, really. So the only way to change a Supreme Court binding decision is to come back to statute and say, nope, that's enough. Now, so there is a particular case that's currently just gone through about staff members who are what's known as term time only, or only work for specific parts of the year, even though they're employed for an entire year. The decision is currently considered to be incorrect. That it's providing an inequitable sort of decision for employers, and so it's probably going to have to be overturned by statute because the judge feels like they got it wrong. So it's not a question that the Supreme Court is always perfectly correct. They can quite rightly get things wrong, but the only way to then overturn it, is to go back to statute, or alternatively to prove that they were misinformed. I think that one probably an inability to be able to add. I'm not sure whether that's going to work with a judge. So there's our court hierarchy. In terms of our tribunals, then, these are not courts. They are tribunals where decisions can be made. So employment tribunals is the key example of those ones where disputes over employment law are brought. They have some advantages. They've got judges that are experts in the area, such as employment law. The process is typically faster. They are less formal, but there's still a lot of proceedings, and there's still considerable work required and process to be followed with an employment tribunal. The one downside, I think, on tribunals is that they're not bound by the doctrine of precedent, so the same circumstances can yield different outcomes based upon the views of the judge. So that is a downside, actually, to be fair. I think the judicial precedent is a much better system. They don't offer the ability for legal aid, although lawyers can take their cases on the basis of no win, no fees, but costs aren't awarded either through the tribunal system, which again is annoying because it means that disgruntled employees can use the employment law and employment tribunal system as a way to just sort of irritate employers and try and almost hold them to ransom through costs in order to get some money and a bit of a payoff out of them. So tribunals do have a sort of a downside. They should be costs being awarded, and it should be much harder to bring them in the cases. You might disagree. You could go the other side and say that access to justice is vital regardless of the cost. So that's a run through of the in the English legal system. Just in terms of your key points, you've got those key points, which are the key points to be taken out from this chapter, really, and then just listen to this again and try and just get it to sink in. In the next chapter, we're going to consider contract law. So in terms of our 7-mark question, really, in here, that English legal system, probably 3 marks, and then contract law is going to have another 4. So it's not a lot of marks for what we've gone through as 20-odd minutes, really. So just don't get sucked up into this area. Try and just make sure that you've got the general overview of what's going on in the split between criminal and civil. And the idea between punishment on the civil side, restitution on the civil side, and then in contract law we're going to go through the civil side in more detail. Hope you listen. Thanks for listening. See you on the next one. Bye bye.